Steve, we understand that retirement plans can be somewhat tricky when it comes to a divorce. Can you shed some light as to how the courts determine the division of those assets?
That's a very good question. The reason is because you have different types of plans that must be divided in different manners. In fact, retirements are one of the most complicated issues that you'll deal with in a divorce and should have an attorney to help you with. There are basically two different types of retirements: defined benefit plans and defined contribution plans. Defined benefit plans are not primarily based on contributions, but rather on how long you work and possibly some multiple of what your pay was. For example, a lot of government retirements are like that. For example, FERS with the federal government. A military retirement is exactly like that, not based on any contribution. Defined contribution plan is a savings plan or a 401k, where how much you get out is based on what you put in. Now, those are all employment-related plans, and you do also have your IRAs and SEP IRAs, which also need to be divided but are much easier. What complicates them is after the judgment is entered, you need to determine what type of plan you have and how it will be divided. If it's a private employment plan like a 401k, you will require a special document that we refer to as a quadro, a qualified domestic relations order. If you have some other type of non-defined contribution plan like a military retirement, you may also need to submit additional forms and orders after judgment. So there's a lot of work that's done in dividing retirements after the judgment's been entered that will be considered in expecting when you will get those funds.